Right. Welcome everyone. As you're joining us, I want to get started with a short introduction. So hello and welcome to World Farm Animals Day, and also the first event in this year's Animal Law and Policy Program speaker series. So I'm Kristen Stilt. I'm a professor at the law school and the founder and faculty director of the Harvard Animal Law and Policy Program. Today we are so pleased and truly honored to be hearing from our clinic director, Professor Kathy Meyer, who has been a remarkable mentor to our students, preparing them to become skilled attorneys and future leaders in the field. In fact, many prominent figures in the animal protection movement today received their first training from Kathy at her law firm, Meyer and Glitzenstein, including those now at Lewis and Clark's Animal Law Litigation Clinic, Yale's Law, Animals, and Ethics Program, Animal Outlook, the Animal Welfare Institute, the Good Food Institute, Reyes for Animals, and the Humane Society of the United States. Kathy is truly a leader in this field and a mentor and teacher, and we could not be happier to have her here with us at the clinic. So we'll be hosting a full slate of engaging events this academic year, and we have an impressive cohort of policy and research fellows to hear from too. So I do invite you to keep up with our work, to keep up with the events we're hosting by signing up for our mailing list, which you'll see in links in the chat section. And also, please submit any questions you have for Kathy in the Q&A feature, and she will get to those at the end of her presentation. So thank you all so much for joining us and supporting the work we're doing on behalf of animals here at Harvard Law School. With that, I want to turn things over to Elizabeth Malampy, the co-president of the Harvard Animal Law Society, which is co-hosting today's event. Elizabeth.
Thank you so much, Professor Still. It is my absolute pleasure to introduce our speaker today. Professor Kathy Meyer has extensive experience litigating cases under the Endangered Species Act, the National Environmental Policy Act, the Animal Welfare Act, the Freedom of Information Act, and other environmental, animal, and open government laws. Professor Meyer was a founding partner of the public interest law firm Meyer, Glitzenstein, and Eubanks, which was hailed as the most effective public interest law firm in Washington, D.C. She has decades of federal and state court litigation experience and is known for finding innovative ways to advance her clients' interests. Professor Meyer is currently the director of the Animal Law and Policy Clinic here at Harvard Law School, where she supervises and guides student attorneys in a variety of animal law-related projects, including both litigation and policy work. I was lucky enough to participate in the Animal Law and Policy Clinic in its inaugural semester last year, where I worked with Professor Meyer to research various causes of action and construct novel legal theories to help animals. This semester, I'm lucky enough to be back in the clinic, working on one of the pieces of litigation that Professor Meyer will talk about today. Professor Meyer runs her clinic like a public interest law firm, where each student has true ownership over a project, creating a learning environment that is filled with both responsibility and opportunity, unlike anything else I've experienced at the law school. Through the clinic, I've developed concrete advocacy and litigation skills, improved my research and writing, and learned quite a lot of substantive animal law concerning animals and their protection. One of the best parts of the clinical experience is to hear Professor Meyer's stories and to learn from her varied experiences in this field. And today, on World Farm Animals Day, we're so excited to have Professor Meyer talk about some of those experiences, litigating on behalf of farmed animals. So please join me in welcoming Professor Meyer.
Thank you so much for both of those lovely introductions. I really don't deserve it, but I'll take it. It's always nice to hear. And in honor of the World celebration today, I have a painting of a chicken that our daughter did many years ago. So I thought I'd put that up as my background. It's so great to be here, and Elizabeth, to be introduced by Elizabeth, one of my many outstanding students in the clinic. We're very glad to have her back this semester because she's absolutely outstanding, as are all of our students. I wish I could be with you all in person. It's kind of strange just staring at myself in a little box on a screen, but such is the way things are these days. I was asked to give a little bit of background about myself and sort of my path to how I got to be an animal lawyer. So I thought I would do that for a bit, and then talk about how I ended up at Harvard Law School teaching this clinic, and then segue into some of the cases that we're working on right now. So I grew up in a small town in Ohio, and when I went to college, I heard consumer advocate Ralph Nader on the radio talking about something incredibly inspiring, and I decided that's it, I want to be a public interest lawyer. I then made my way to Washington, D.C., which is where Ralph was and where the public interest hub of the country was, and went to law school here in D.C. I'm speaking to you from D.C., where I live. And while I was in law school, I did a lot of public interest law. I worked for the ACLU. I worked for a civil rights clinic. I did a lot of internships. And I mean, I was dedicated to being a public interest lawyer. And then I found my way after graduation to a small firm that was actually started up by a couple of former Nader people, and worked there for a while, and then went off to the Center for Auto Safety, which was one of Ralph's initial groups, and then made my way eventually to where I wanted to be, which was the Public Citizen Litigation Group, which was the litigation arm of the entire Nader network, and run by Alan Morrison, a 1966 graduate of Harvard. And that's where I really honed my skills and learned to be a litigator on behalf of many different kinds of clients. It's also where I met my husband and partner, Eric Lisenstein, who will actually be teaching the wildlife law class in the spring semester. So some of you will get to meet him as well. I've always been a huge lover of nature and animals. I always had dogs and cats in our family when we were growing up, and always wanted to do something meaningful with my life and with my career. And when Eric and I left the litigation group, where we had done quite a bit of work on behalf of various clients, we decided to try to use the skills we had learned there and transform those skills to the environmental animal law world. And that's basically what we tried to do, and we're somewhat successful in the many years that we had our firm, basically using the strategies and Administrative Procedure Act lessons and skills that we had learned in other contexts, and then applied them to trying to help our many environmental clients and animal law clients achieve their objectives. So that's kind of what we're also doing in the clinic, is trying to both use the existing laws and trying to expand existing laws to protect animals and to advocate for them. So last year, after 26 years in private practice, I came to Harvard. I was asked to help launch the inaugural clinic here, the Animal Law and Policy Clinic, and I was pleased to do so. I was excited about it because I had so many contacts in the environmental and animal law world by then, that it was exciting to think that I could come in and really kind of hit the ground running with ideas for cases and projects, and so many contacts with groups around the country, grassroots groups and the big national groups. And I knew that they would want to feed us ideas as well, because now they were getting basically my work and for free through the Harvard Law Clinic. And it was great for me because I was getting to work on cases that I really wanted to do and projects that I wanted to do without having to worry about financing them, which is what one has to do when you're in private practice. So it was a great opportunity, and I'm so pleased. And Professor Stilt and Dean Manning and the whole team at Harvard Law School have been incredibly gracious and giving us wide latitude in what we do. And as Elizabeth mentioned, we run our clinic as a public interest firm, and we try to give Nicole Negawetti, our clinical instructor, and I try to give the students as much responsibility as we can. And we're trying to teach them how to do these cases and how to work up advocacy in many different forums on behalf of animals and our clients. And we let the students, meet with the clients, meet with the experts, figure out the arguments, draft the briefs, draft the complaints with our supervision. But we really do want them to learn by doing. And so far, we've just been incredibly pleased with the caliber of work that the students have done and the enthusiasm that they bring to the clinic. So we've already done a whole range of projects starting last year, both in terms of subject matter and advocacy tools from protecting the butterflies on the Mexican-US border from the border wall that President Trump wants to build, to coming up with innovative strategies to do something about climate change, to reduce the amount of plastic in the ocean, which is incredibly deleterious to marine life. And under the leadership of Nicole Negawetti, we also have done quite a few projects on trying to level the playing field for non-meat protein as an additional way to protect animals, in the hope that this will reduce the number of animals that are used for food. So with that introduction, I'm going to talk about two of our farmed animal cases that we're doing presently in the clinic. The first is our Kphone case. So this is a case we're doing on behalf of two families who live in Indiana, the Himsels and the Lannons, and they have lived on these incredibly beautiful bucolic farms for decades. In the case of the Himsels, the original homestead, I think, was in the 1920s. And they've been there and they've very much enjoyed their traditional farming life. They have some animals, they have beautiful land. It's absolutely, rolling hills, and it's absolutely beautiful. And they enjoyed, being outside and gardening and interacting with the wildlife, and having their children over and their grandchildren over, and having a cup of coffee sitting outside. As you all know, now with the pandemic, some of us who are lucky enough to have an outside space, we like to be as outside as much as possible. And the Himsels and Lannons for years lived a very lovely life on their farms in Indiana. In 2005, the Indiana legislature amended that state's Right to Farm Act to basically eliminate any claim for nuisance caused by the siting of a concentrated animal feeding operation, which, as many of you know, is referred to as a Kphone. And these are massive factory farms where they produce tens of thousands of animals, pigs, chickens, cows, in confined spaces, densely packed, with absolutely no semblance of any kind of natural life at all. These animals do not stand on grass. They are not allowed to interact with each other. They are separated from their progeny. They are just basically treated as widgets in a factory. They are not treated as sentient human beings whatsoever. And I know pretty much all of you attending this understand how horrible this situation. And these Kphones produce so much waste, animal waste, urine, feces, and other waste, that they have erected these huge pits in the Kphone to catch all of the waste. And then, because the odor from the waste would be so toxic to the animals that it would kill them, they have these huge fans that blow the odors and the waste particles off of the Kphone's land into the air, and it wafts over and lands on the neighboring property, which is exactly what happened to our clients. So what happens is the Farm Bureau and other industrial farm interests know that if these Kphones didn't get some kind of special protection under the law, they would be liable for nuisance under basic nuisance law. And so they have been going to the various legislatures around the country and getting these special statutes and special amendments to statutes passed that provides for total immunity for those kinds of lawsuits. And that is precisely what happened in Indiana. And this is necessary because under traditional property law, if someone moves next to a nuisance, and let's say you moved into the farm after the Kphone was already there, you wouldn't have a claim of nuisance because it would be barred by the basic doctrine that you can't have a claim for nuisance where you moved to the nuisance. I'm telling you that now because that becomes important for what happened in this case. And these Kphones are increasing by the day. They are just, traditional farms are, as I'm sure you all know, they're just not producing the food that the animal food that people are eating. It's these Kphones. I think it's in 2017, which is the figure we cite in our brief. 94% of all hogs, for example, were produced in the United States in CAFOs. So in 2013, relying on this amendment to the Right to Farm Act, a CAFO was cited next to our property, next to our client's property. And as a result, all those things I told you that our clients loved about their property and loved about their lives are gone. They can no longer, the odor is so horrible, and the waste particles in the air are so toxic, they literally cannot sit outside in the morning and have a cup of coffee. They can't garden anymore. They can't even have their grandchildren over to visit. All of this was established in the record. Their lives have become very, very different from what they had experienced for decades. Even with the windows shut inside their homes and all kinds of fans blowing and air conditioning and everything else, it does not cure the problem. And they've been suffering health problems, and just their entire way of life has just been completely ruined. So represented initially by an Indiana nonprofit group called the Hoosier Environmental Council, that entity brought a lawsuit in state court in Indiana challenging a nuisance claim and a trespass claim against the CAFO, and lost both in the trial court and in the Court of Appeals. And the Court of Appeals of Indiana actually ruled that the statute not only barred the nuisance claim, the amendment to the Right to Farm Act not only barred the nuisance claim, but also barred a trespass claim. And our clients argued that in addition to the odors, these waste particles that land on their property also gives rise to a trespass claim. And the Court of Appeals ruled that neither one of those claims could go forward. And actually said, I just want to read it to you because so you know that I'm not paraphrasing here. The Court of Appeals actually said that the coming to the nuisance doctrine as applied by the Indiana Right to Farm Act now encompasses coming to the potential future nuisance. So basically the court was saying our clients are at fault for living on property since 1920. They should have known that in the future, in 2013, a CAFO was going to move in next door, and therefore their nuisance claim was barred. That is what the court ruled. So Kim Ferraro, who was the staff attorney for the Hoosier Environmental Council, had litigated this case both in the trial court in Indiana and in the Court of Appeals. And Nicole Negawetti, who had worked with Kim, invited her to speak to our class the first semester of our inaugural year of the clinic last year. And she presented this case to us, and we were just mortified. I mean, we were just all sitting there going, what? This can't possibly be true. And we said, and at that point, she was trying to get the Indiana Supreme Court to take the case up further. And we said, well, if the Indiana Supreme Court, depending on what the Indiana Supreme Court does, you know, we're interested in perhaps taking this to the US Supreme Court. And the argument is, and this was alleged below, that if in fact this state statute deprives our clients of any opportunity to sue for nuisance or trespass or get any relief whatsoever for what has occurred here, then that constitutes an unconstitutional taking of their property without just compensation. It probably goes without saying that our clients can't possibly sell their property now for anything remotely close to what it would otherwise be worth, because who wants to move in there? And it's interesting, a CAFO wouldn't even be able to move in there at this point because of the zoning requirements. But anyway, so sure enough, the state Supreme Court, in a very close decision, a 3-2 split, ruled against our clients. And at that point, we decided to go ahead and try to seek cert for the Supreme Court. So actually, with the help of Andy, who is, I think, on this somewhere here, Andy Savach, who is hosting this entire webinar, and Boanne Wassink, who graduated last year, they drafted the initial cert petition for the Supreme Court, which we were able to file this summer. And the two grounds for seeking cert, generally speaking, are that there's an important constitutional issue at stake, particularly with respect to what the state court has done with respect to the trespass claim. Because under Supreme Court takings jurisprudence, it's well established that if there is a permanent, government-sanctioned permanent physical intrusion of someone's property, that is a per se taking. Yet the Indiana courts said there was no viable trespass claim, and therefore we're saying that that is a violation of the takings clause and runs counter to well-established Supreme Court takings jurisprudence. In addition to that, we have told the court there's also a divergence among the states and how they're interpreting these Right to Farm Act statutes and amendments. And there's actually a split with Indiana, with Iowa and Indiana, and other courts around the country are coming out differently on this takings question. And so we've asked the court for that additional reason to take the case up. And we have now fully briefed the case in the Supreme Court. Our reply brief was filed last Friday. And I think it's scheduled for conference very soon, right after the court reconvenes next week. So we'll probably have an answer pretty soon. I'm glad I got to do this before we got the answer, because as many of you probably know, your chances of getting the Supreme Court to take cert in any particular case is very slim. They take about 1% of all of the petitions for cert that they receive. So we're hopeful, and we think we've given it the best shot we can. So we'll definitely keep you posted on that, or just stay tuned and we'll let you know what happened there. So that's the first case I wanted to talk about. The second case is a case we're doing under the Poultry Products Inspection Act. Let me get some water there. So this is our effort to do something on behalf of the 9 billion chickens and turkeys that are slaughtered every year in this country for food. As many of you probably know, there's a statute called the Humane Methods of Slaughter Act, which protects certain categories of animals, minimally protects certain categories of animals that are slaughtered for food. Cows, swine, horses. Horses aren't slaughtered for food, are they? I don't think so anymore. But it does not apply to chickens. It does not apply to birds. So they are completely unprotected. So the Poultry Product Inspection Act is basically a consumer protection statute. It's not an animal protection statute per se. It is a statute that governs how poultry is treated at the slaughterhouse, and the goal is to prevent adulteration. So products that are adulterated are not allowed to leave the slaughterhouse and go to the market. They are supposed to be condemned by USDA inspectors and prohibited from being sold to the public. So that the basic thrust of the statute is to protect humans from getting adulterated products, poultry products in the marketplace. Unlike the Humane Methods of Slaughter Act, there is absolutely nothing in the statute that pertains to protecting the animals themselves. However, in recent years, the USDA, and in particular the Food Safety and Inspection Service, which is a division of the USDA that has jurisdiction under this statute, has acknowledged on several different occasions in writing that there is a link between the inhumane treatment of animals, of these chickens and turkeys, and the resultant adulteration of the product. So once our clients, in this case the Animal Welfare Institute and Farm Sanctuary, saw that the USDA itself was acknowledging the link between inhumane handling and adulterated poultry products, they submitted a rulemaking petition, as one can do under the Administrative Procedure Act. My students are learning a lot about that, to the USDA and said, all right, now that you've established the link, we want you to start regulating how the poultry is treated. And we want you to issue standards that would govern the humane handling and other practices with respect to poultry at the slaughterhouse. So what happened was those petitions were considered for a while, but last year were denied by the USDA. And interesting, they had two, what we regard to be as completely inconsistent reasons for denying the petition. Number one reason they gave for denying that petition was they don't have jurisdiction over humane handling of poultry under the Poultry Product Inspection Act. Number two reason for denying the petition was the system they currently have in place, under which they rely on good commercial practices of the industry, that is addressing the problem of the inhumane handling of poultry, which they just said they don't have any jurisdiction over. So anyway, they don't have any jurisdiction over it, but their current system is addressing that problem just fine. So therefore, there was no need to promulgate any standards. So Animal Welfare Institute and Farm Sanctuary asked our clinic if we would consider representing them in a challenge to that decision, and we said yes. And actually, Elizabeth, who introduced me, and Susanna Benjamin, another member of our clinic this semester, are working on that case. And we filed it this summer. It's pending in the Western District of New York, which is where Farm Sanctuary had venue. And our main claims in that case are that the denial of the petition violates the agency's statutory command to prevent adulteration when it has conceded there is a link between the inhumane practices that go on with respect to poultry in these plants and the subsequent adulteration of the product that ends up in the market. And number two, that the agency's reliance on these good commercial practices is arbitrary and capricious, which is the standard for review under the Administrative Procedure Act, because it relies on, because there's a whole slew of inhumane practices that are not even covered by these good commercial practices, and these good commercial practices that are devised by the industry themselves are incredibly vague and not uniformly enforced throughout the country. So that is sort of in essence what our claims are. And we anticipate getting a motion to dismiss or an answer, one or the other, pretty soon. And so the students, in anticipation of that, are already drafting their opposition to a potential motion to dismiss, should that be filed by the government. So those are the two main cases that we're working on that touch on farmed animal issues. We're also working on something that's sort of tangentially related to that, which is we're trying to help protect the Thule elk, which is a population of very special elk that were almost extirpated from an area in Northern California many years ago, and then reintroduced and are now protected by statute in Reyes National Seashore. I'm sure some of you have read about this in the paper because it's a very controversial issue. So this is Reyes National Seashore in Northern California, one of the most beautiful places in the world, as far as I'm concerned. Absolutely beautiful. And there are hundreds of these Thule elk, which are a special species of elk that live there and are protected by statute. And unfortunately, because of the drought conditions going on right now, there's a scarcity of water at the seashore. And this is extremely exacerbated by the fact that these elk are actually confined to a certain area by a large 8-foot fence that has been erected around the population at the behest of the livestock industry, because there are lots of cows out there that are also grazing on public property, and they don't like the elk competing with the cows. The livestock owners don't like the elk competing with the cows for forage and for water sources. And as a result, you have this horrible situation where the cows, who are not protected by any federal statute that I'm aware of, have access to the water, the scarce water sources And the elk, who are supposed to be protected by federal statute, are being deprived of the water. And activists on the ground are monitoring this and have so far have counted about 15, maybe more by now, elk who unfortunately have died, seemingly from a lack of water. And it's just a horrendous, horrendous situation. So we were asked to get involved with this. And it's particularly ominous because the last time this happened in 2012 and 2014, when there was a serious drought situation in this area, half the population of elk died from a lack of water. I think like 200 and some elk died of thirst. Which is you can imagine, just a horrific way for an animal to die. So, so we're very concerned about the situation, and we were asked if we could do something about it. And there's a lot going on, and I won't, go into all of the detail now, and some of it requires discussion of attorney-client privilege strategies, which I can't get into, but one thing I can tell you is when we were asked to get involved, one of the first things we did is on behalf of the Center for Biological Diversity, which is a national environmental group that is headquartered out in the West. And has been very involved in this issue. We sent a letter to the Park Service back in August telling them of our grave concern about the situation and asking them to, among other things, take down the fence so that the elk can get access to the water sources that they need. And if they're not going to take down the fence, to at least make sure during this drought period that adequate water is brought into the elk so that they don't die. And the National Park Service in response insists that there's plenty of water available for the elk, that if they know where to go, they can get access to certain seeps from creeks, and there's still plenty of water there for the elk, and to date have not agreed certainly to take down the fence that the livestock industry wants to keep up there. And unfortunately what's going on now is the activists on the ground there, who are just horrified by what's going on, they're actually trying to bring in water. You may have seen this on the news. It's quite an amazing situation. So that's kind of in a holding pattern. We're trying to get as much evidence as we can to validate the fact that these water sources that the Park Service says are available to the elk, in fact, are not available to the elk. And so that's another matter that's ongoing, and we will keep you posted on that as well. So I just wanted to say, in addition to all of that, those cases that are going on, which we decided to focus on because it's World Farm Animal Day, we're doing a whole range of other kinds of cases right now. And it's just a really exciting clinic and exciting projects that we're working on. I can't really go into too much detail about them. But a wide variety of advocacy, and not just subject matter, but also tools. So we're not just doing litigation, we're also doing, we're writing policy papers, we've done some legislative work. We've been working with members of Congress on trying to get legislation passed, rulemaking petitions under the Administrative Procedure Act, a whole host of advocacy tools that we're trying to teach our students how to avail themselves of in their quest to help protect animals, and also to learn how to be lawyers in the real world. So stay tuned for more, and I'd be more than happy to answer any questions anybody has.
Okay, great. Thank you so much, Kathy. We do have a couple questions that have been sent in. The first one is from John Bell. He asks, is there hope we can get federal subsidies for plant-based agriculture, the same kind of federal subsidies as the meat/cattle industry? That would help lower the prices of plant-based alternatives and make it easier for the public to try them.
Is there hope? There's always hope. Yes, the answer is yes. There's hope, but we're talking about huge well-heeled lobbying interests on the other side. And so it's going to just take a lot of work on the Hill, a lot of education, a lot of educating of the Congress people who have the power to do that, and a lot of grassroots organizing and a lot of pressure brought to bear, and a lot of education about, you know, the evils of meat and the healthy and other environmental attributes of non-meat alternatives, etc. But yeah, the subsidies issue is a huge problem.
Great. We've got two questions related to the Indiana Kphone case. First is also a follow-up from John Bell. I'll ask them both and then you can answer. First is from John Bell, who asks, if you win in the Supreme Court, would this only apply in Indiana and the other states would have to fight their own battles? And then following up to that from Nirva Patel, asks, if the Kphone wins, the land essentially becomes Kphone land and anyone in the future would be coming to the nuisance and have no right to the land. Isn't this a de facto case of eminent domain, eternally zoned, if the government funds CAFOs?
A lot in there. Well, regardless of if we don't prevail in trying to get this case on the merits before the Supreme Court, the status quo will be, as you say, Kphone land in Indiana. I mean, that's the status quo right now. There's nothing anybody can do about it. This is our last effort to try to change that situation. And what's the first part of the question?
First part of the question was if you win in if you win in Indiana.
Oh yeah, will it have any wide
effect?
Yeah, thanks. So they're kind of related, as you said. I mean, obviously it would depend. I mean, right now we're just trying to get the Supreme Court to take the case. That's like step one. If they take the case, step two would be we would then argue the merits of our case. We're not at the merit stage, but if we get to the merit stage and if we win, it would depend on how the court writes its decision in terms of whether it just would apply to the Indiana statute, or because of the way the court writes its decision, it would apply much more broadly to some of these other states that have undertaken similar efforts to provide immunity for CAFOs from nuisance and trespass law, nuisance and trespass claims.
Great. We have two questions from Louisa McCune. She says she's intrigued by the idea of model litigation regarding animals, sort of like model legislation, but within the courts. Can you speak to that idea? And then she also says she's very curious about antitrust and anti-competition work within the DOJ. Can you speak to that generally? She's like, I'm a non-lawyer, so forgive the broad nature of the questions.
I'm not even sure what she's talking about. Do you know? I don't know what model litigation is.
Well, just the idea of what you're doing to like kind of work out these new causes of action through the clinic that other people can then go in an animal protection community can then go and sort of weaponize and use on their own as well.
Oh yeah, definitely.
Sort of an incubator, like the Harvard Animal Law and Policy Clinic being an incubator for these new ideas and causes.
I see. Okay, I didn't know mono. I didn't know the mono part was what threw me. Yeah, I mean that's the plan. I mean that's always the plan when you're doing public interest advocacy work, is to try to take what's on. I mean, there are others out there trying to make brand new laws, which is great. And I hope that all succeeds. But in the meantime, we're trying to take the laws we already have and in an innovative way, use them to advance the cause of animals, animal protection, animal welfare, et cetera. And, you know, to the extent you can do that step by step, incrementally, it does create a template for the next case. I mean, there are so many barriers to bringing these cases. I mean, I could do a whole presentation on the barriers itself. I mean, there are Article 3 standing issues. There are, you know, all the cards are stacked against us in terms of not only the way the laws are written, but the way the laws are enforced or lack of enforcement, and there's no way to challenge the lack of enforcement. So there's a lot of impediments to bringing these kinds of cases, and we're trying to chip away at those impediments one by one. And yes, we always hope that whenever we bring one case that is successful in one area of animal law, it can then be used again and again and again to advocate for animals. So that's definitely the goal, and we hope that we're succeeding in that. I mean, that was our goal also when I was in private practice, and it turned out, you know, we lost a lot of cases, but we won a lot of cases too. I don't know anything about antitrust, so I can't go there. Sorry.
Okay, great. And I misspoke there. Is model, sorry, not mono. That was my own pronunciation.
Oh, okay.
Sorry about
I didn't know what, yeah, okay.
So we've got a few more questions here. This is something you know quite a bit about, but it's a very broad question. This is from Angie Vega, and she asks, how do you get standing to challenge a regulation that is affecting the environment or animal welfare?
Oh my goodness, you should have come to our seminar a couple weeks ago. I always start out the clinic with at least one, if not two-hour seminars on Article 3 standing. It's so important. It depends is the answer most lawyers give. I mean, basically, you have to be able to show if you're in federal court, it's a jurisdictional issue, whether the federal courts have subject matter jurisdiction, because the issue is whether or not you've established a case or controversy, which are the magic words in Article 3 that give the court jurisdiction over those cases. And there's just a whole body of case law that has developed as to what those two words mean. I guess a short way of saying it is you have to be able to show that you're injured, a human being is injured somehow by what you're complaining about. And in the environmental and animal context, the general way to do that has been to say, and it's much easier in the environmental context, just to say, our clients like to go to this national park or this, beautiful area. It's going to be degraded by the federal action or private actor action that we are challenging. Therefore, our aesthetic interest in observing, studying, researching, just enjoying this beautiful area has been impaired. That's an injury in fact. And if you can establish that and show that it's caused by what you're complaining about, and that if you prevail in your challenge, those interests will to some extent be redressed by a court ruling in your favor, you have Article 3 standing. The problem with, and that applies to protection of wildlife too, if you are someone who loves to go see elephants in the wild or any species in the wild, and you're complaining about a government action or private actor action under a federal statute that is violating your aesthetic interests, it's harming your aesthetic interests, it's reducing the number of animals you would otherwise be able to see, that's well established as a basis for standing. The tricky part is when you're trying to protect captive animals in captivity, and where you can't make similar kinds of arguments. And in that area of standing law, there has been quite a lot of development since the late 1990s. And as the case law now stands, as long as you can establish that you have a particular aesthetic interest in a particular animal, let's say the typical case is at a zoo. There's been a lot of litigation challenging roadside zoos in the past few years. And the basic standing goes like this. We have members, or we have individual plaintiffs who enjoy going to that zoo because they like visiting those particular animals. They've gotten to know those particular animals. They've formed a bond with those animals. And because the animals are being treated inhumanely in violation of, you have to have, the Endangered Species Act if it's a listed species, or because of a regulation that the USDA has issued in the case of some challenge to primate litigations that we did a few years ago, you're being harmed, your aesthetic interest in observing and enjoying and viewing those animals is harmed. If you can show that, and it's not easy to do that because it's hard to find those people. If you can show that, you have an injury in fact, and you have the necessary causation and redressability. So there's a lot of work going on right now in that area, and we're trying to expand the basis upon which a standing can be established to bring those kinds of cases. And then there's a whole another set of cases I'm sure you all know about that people are doing to try to establish that the animals themselves have standing to complain about the way they're being treated. So that's a whole nother very important advocacy, forum for advocacy on behalf of animals by the Non-Human Rights Project, and other groups, ALDF and PETA, are bringing those kinds of cases as well. So we're trying, we're working on it.
Great. We have another question here from Melody Mathewson, who asks, thanks you for speaking. And do you think the COVID situation and various lawsuits / regulations will help or hurt the meatpacking industry in the long run? As in, will it make their ability to exist and operate more difficult in any way?
I hope so. Let's hope so. I mean, you know, when you try to look for silver linings in the middle of a global pandemic, it's hard to find one, but the notion that perhaps this situation is really educating people about some of these problems and educating people about the importance of science and the importance of, you know, what can happen when animals are mistreated, when animals and humans are in artificially, you know, designed spaces together and can transmit, diseases can be transmitted from animals to humans, and given, you know, our dense population of humans, what that can mean for, you know, the health of the world. All of these issues are coming, and the way workers are treated in these slaughterhouses, et cetera, meat packing plants. I mean, all of these issues, which were talked about by some people, some of us, but now they're on the front page of the newspaper. I mean, they are issues that are, you know, front and center right now. And I always think that public education is the key to moving forward on these issues. And the more people know, and the more people can be concerned about what's going on and realize there are solutions, the better off we're all going to be. So I think in a strange kind of way, what's going on right now, the fact that it's highlighting some of these very important issues is very useful.
Great. We've got a follow-up from Joy Nacrin, who asks, what about the HSUS suit against the USDA for policies that put us at risk for future pandemics? What do you think of that outlook?
I am not involved in that case. I know that it was filed, and I hope that it gets some traction. I'm all in favor of what they're trying to accomplish in that case. I'm not even sure what the status of it is right now. I don't think it's progressed to the merits, certainly not progressed to the merits yet, but yeah, very supportive of all of these efforts.
And you had mentioned speaking about your first two seminars focusing on Article 3 standing, and someone asked if those were recorded, and they are not, but didn't you do an animal law podcast based on standing about the chimpanzee cases? Does that cover standing?
Yeah, the Yerkes case. Yeah, that we covered standing a little bit. And I think, yeah, we can't record our seminars because, as I mentioned, we really do run our clinic as a public interest law firm, and there's a lot of confidential discussion that goes on, strategy and discussion about, you know, what issues we should pursue, what issues are strong, what issues are weak. What clients we may want to reach out to pursue certain things. I mean, there's just so much attorney work product and attorney client discussion that goes on at our seminars, because it's just such an integral part of the clinic itself that we can't record them. So I think in the future I'm going to be doing some recorded lecture on Article 3 for the Brooks Institute, perhaps.
Great. Yeah, that's right. The Brooks
That'll be available.
Series. Yeah, so that should be available for too long.
Yeah.
We'll make sure to spread that far and wide when it happens.
Yeah.
We've got another very broad question, but a good one from Kishore Dare, who asks, which are the toughest intellectual challenges, according to you, when it comes to promoting animal rights and enforcing animal law?
Intellectual challenges. Well, Article 3 standing, the bane of my existence. I mean, it's just so ridiculous when you look at the Constitution, and it says federal courts have jurisdiction over cases or controversies. And those seem like really broad terms to me. And as I always tell my students, I've never brought a case in my life that wasn't both a case and a controversy. So that should be the end of that. And yet it's the justices who purport to be the strict constructionists of the original words of the Constitution who have imposed all of these rules on how public interest plaintiffs get standing or don't get standing. So I think that, I mean, if you can't get through the courthouse doors, you can have the greatest case in the world and the most egregious situation in the world, but there's nothing you can do about it. So I think intellectually continuing to work on that issue and expanding the ways and the circumstances under which we can bring these cases is huge. I mean, another, and this isn't really an intellectual challenge, but it falls within that general category, is we have these statutes that are not enforceable because there's no, for example, the Animal Welfare Act, which on its face is like the federal statute that protects animals used in exhibitions and in research and in pet trade, and yet it doesn't have a private right of action. Unlike all the environmental statutes, pretty much all of the environmental statutes, the Endangered Species Act, the Clean Water Act, the Clean Air Act, they have provisions in those statutes that allow citizens who have Article 3 standing to bring lawsuits directly against the violator of the law. Well, the Animal Welfare Act doesn't have a private right of action. And so the only entity that can enforce that statute is the United States Department of Agriculture. And it is notorious for not enforcing that statute. Year after year after year, its own inspector general issues reports saying that the statute's just not enforced by the agency. So that is a huge challenge. And I think in terms of intellectual challenge, I think it's really just, I think this is changing drastically though, for the good. It's getting people to understand that animals, we're all animals. Humans are animals, and animals, regardless of their species, deserve to be treated with respect. They suffer. They, you know, they have important lives, that they have families, they have superpowers that we don't even understand, that are amazing, miraculous. And I think getting people to get that and understand that, instead of just shutting down when they think, you know, any non-human animal is like worth less than a human being, that is an intellectual challenge. But I think that's changing so drastically right now. The more people can see things with their own eyes, the videos that are out there, and the more animal law that's done, and the more discussion like this and these courses that are being taught around the country, and these clinics, these fantastic clinics that are being run, animal law clinics at other schools as well. And I think that is really changing in a very good way. So hopefully it'll continue to change in the right direction.
Great. This question follows up on that a little bit. It's from Manisha Dekka. And she says, she thanks you for your wealth of experience and asks, what type of public education do you think would be most beneficial in reaching regulators to initiate change? Or do you think that developing individual relationships between animal lawyers and other advocates is a key pathway towards law reform?
I think both. I think everything contributes to the whole. So I think educating regulators, very important. I mean, you know, there's a lot of really good people that are, you know, in the government that maybe just don't understand or appreciate some of the things that we've been talking about. And I think spending time educating people and doing advocacy work on many different fronts, doing rulemaking petitions, you know, bringing cases, writing white papers, meeting with as many people in as many different contexts. I think public education in the schools, getting to kids when they're little, I think all of these efforts are important and contribute to advancing the cause for protecting animals. I mean, anybody who has children knows, you know, children are naturally, they naturally love animals. I mean, they have to sort of be taught not to love them as they get older. I mean, children just are naturally drawn to animals and appreciate them and have a rapport with animals that unfortunately is somehow in many cases disappears for some people when they get older. And I think if you could capture that, if you could keep that going, if we could get into the elementary schools and nurture that and expand that way of thinking, that would be a huge advantage for the world, and just this whole realm of public education that we're talking about.
Great. We've got probably room for two final questions. I'll ask them both at the same time and you can address them. One is from Piper Hoffman, who's an alum who was actually responsible for getting the first animal law courts taught.
I remember Piper. Piper, I remember you.
She asked, have you seen opportunities for litigation benefiting farmed animals that the clinic has not been able to bring for one reason or another? And then we have another question from Megan Jones asking, is there anything that non-lawyers can do to support this type of work, either at the clinic or elsewhere?
That's so cool that Piper's here. I met Piper, oh my God, Piper, like 1993 or 4 or something, a long time ago. I think that's who you are. But anyway, what did she ask me? Sorry. Oh, are there any barriers to bringing these kinds of cases?
Well, she was asking if you've seen any opportunities for litigation benefiting farmed animals that
we haven't. Oh, I'm sure. I'm sure. We have so many projects. We have a lot of projects. We don't have that many students right now, mainly because of the pandemic. I mean, it was really wonderful that we got as many students as we did. Most would like to be there in person to take a clinic, but we have so many projects. It's like, we have no shortage of projects. I'm sure there are many, and we're trying to do projects in many different, spheres of animal protection. We're doing Endangered Species Act cases. We're doing wild horse cases. We're doing primate protection cases, and we're doing these farmed animal cases. So I'm sure there must be many. I'm all ears. We're all ears. Send us your ideas, and we would love to collaborate and strategize for more and more ways to do these things. I think petitions, particularly if there may be a change in administrations, is something that lends itself well to trying to change the law. And certainly we have clients who are doing that now, and that may be something that we do more of in the clinic as time goes on. But if you have any ideas, call me.
Okay, great.
Second question was,
what is there anything non-lawyers can do to support this type of work, either at the clinic or elsewhere?
Well, non-lawyers can continue to educate the public about these issues, talk to their friends, their families, read, use social media to spread the word about some of these practices and what's going on out there. Talk to your representatives in Congress, all of those kinds of things. Organizing, all very important. All of these avenues of advocacy from all walks of life, they all contribute to this cause, and it's very important. In terms of helping our clinic, we haven't had any non-lawyers helping our clinic yet, but that doesn't mean there wouldn't be an opportunity at some point. So let us know what you're interested in doing. We'll see if we can find a niche for you.
Okay, great. Well, we are at 12 o'clock, so thank you so much. Apologize we didn't get to ask all the questions that were sent, but please feel free to follow us on Facebook, Twitter, and Instagram, and at our website, which are all posted in the chat. My name is Chris Green. I'm the Executive Director of the Animal Law and Policy Program. And I'd just like to thank Professor Kathy Meyer. I'd also like to thank our Program Administrator, Kaylee Reddy, our Communications Manager, Sarah Pickering, and the students of the Harvard Animal Law Society for all of their hard work to make today's event possible. So thank you all so much for attending and taking time out of your day as well. And please keep posted as we do more of these.
And stay healthy and vote. Vote.
Thank you so much. Bye-bye.
Thanks.